Welcome to an oral argument session of the 5th District Court of Appeal. Here first on our docket at 9 o'clock, we have case number 20-1221, Peters versus State. On the panel with me this morning, I'm Judge Eisnagel. On the panel, we have Judge Sasso and Judge Nardella. All right, with that, counsel for the appellant, you will be recognized. If you'll just let me know how much time you'd like to have in rebuttal, I will try to remind you when we get there.
Yes, Judge, thank you. 8 minutes, please.
Okay, 8 minutes in rebuttal. I'll do my best to remind you, but you should watch the clock as well. And with that, whenever you're ready.
Good morning, Your Honors. My name is Jason Warner. I'm appellant counsel for Ishmael Peters. Your Honors, may it please the court, Mr. Corrente. Good morning, sir. A trial lawyer in a criminal case, Your Honors, has three basic functions. One is to know the record and know the facts and know the law of the case. The next is to confront the prosecution's case. And thirdly is to present the defendant's case. In the trial of Ishmael Peters, the trial lawyer swung and missed each one of those instances. Ishmael Peters struck out when the lawyer swung and missed 3 times. And he was convicted and sentenced to life in prison. This was a case where there was no forensic evidence, there was no DNA evidence, there was utterly no corroboration whatsoever. The entire case rested on the sworn testimony of multiple witnesses, convicted felons, all who had motivations to lie, motivations to have somebody else take the fall to help themselves. The trial lawyer failed in his job to confront those witnesses and impeach those witnesses, destroying their credibility and the credibility of the state's case with evidence that he had. In some instances, he knew he had it. In some instances, he didn't even know he had it. Either way, he was unable to introduce it in a manner that would be in any way competent. And we take no issue when we agree with the trial lawyer, with the post-conviction court's ruling that the trial lawyer was in fact incompetent. What we take issue with in this appeal is his conclusion that those deficiencies did not prejudice the defendant. That conclusion was erroneous. The case law is clear. In a case where there is little or no corroboration, like here, the defense must impeach the credibility of the witnesses. In this case, that was not done. Had the lawyer adequately used the evidence he had, for instance, the evidence that even this court, in its ruling on the direct appeal, found to be compelling enough to indicate that there was no prejudice for the defendant to bring before the post-conviction court the issue of Denae Craig. Denae Craig gave—
Hold on, counsel. I mean, are you suggesting that this court's prior panel decision affirming without prejudice in some way is controlling here?
No, sir. What I'm saying is the court recognized that there was a legitimate issue with the way the trial lawyer handled the—
or perhaps they just recognized that that based upon the record on direct appeal, that panel could not evaluate the ineffective assistance of counsel claim, right?
Well, and that's exactly what the post-conviction court did. Evaluated it, found it to be deficient, and incompetence. So the question for this panel is, was that incompetence prejudicial? How could it not be? A basic reading of the trial.
Counsel,
in this case-
how many witnesses are we talking about here? How many witnesses does your client have to attack the credibility of in order to prevail on his claim that it was prejudicial?
The only two witnesses to the crime were Kramer and Herringer, and they both were impeached.
What about after the crime, right? You have Taylor.
Taylor was given a free pass, Judge, because he was never prosecuted, even though he fled the jurisdiction right after the crime, even though the main witness, Danae Craig, called him before and after the crime, and even though he was a main suspect by the police until Mr. Kramer's sister pointed out Ishmael Peters. So all of those witnesses rise and fall on their own petard. They're all based upon a flawed premise that Mr. Peters was there. Mr. Kramer's statements to Danae Craig, which Danae Craig clearly
is the theory. I mean, I didn't really pick this up in the record, but is the theory here, is your theory that Mr. Taylor was actually the third person involved in the crime?
There's multiple possibilities. Either it was Taylor, more likely, Your Honor, it was
the cousin?
Relative, excuse me, Judge, more likely it was a relative of Andrew Kramer, who he referred to as, or Danae Craig referred to as cousin Mike, who Andrew Kramer told Danae Craig, I shot the alleged victim, and I was with a white guy who turned out to be Mr. Herringer. And
did he say that to her, or did she assume that just based on the context?
No, Judge. If you look at her sworn statement, there were multiple sworn statements. The trial lawyer had it and never used it when the time was needed to use it. When he got her in front of the jury and tried to proffer her testimony, he didn't even have her sworn statement. Detective Dillon, in his examination, my examination of him before the post-conviction court, was very clear what Danae Craig said. Danae Craig told him multiple occasions that it was Andrew Craig,
what did she say at the evidentiary hearing?
At the evidentiary hearing, she was not there, Judge, because she was deathly ill. The state conceded that she was not needed to be there based upon the plethora of her prior sworn testimony. The tip was consistent with what she had told Detective Dillon. The lawyer didn't even know that the tip existed. This was the kind of deficiencies that occurred in this case. In addition,
the crime line tip now? You're talking about
Judge?
the crime. Are you talking about the crime line tip now?
That is correct, Judge. And the court's ruling on that it was inadmissible is based upon a case that talks about its inadmissibility as hearsay against the defendant, which would run afoul of Crawford, as opposed to being exculpatory evidence, reliable exculpatory evidence that would be admissible under the Chambers and Holmes line of cases. In addition, Judge, the phone records. The phone records are absolutely critical. Why? Because both Harrington and Kramer testified that they connected by phone with Ishmael Peters the day of the crime. That's the kind of corroboration that convicts people all the time. The problem is that the phone records did not actually show that. But this trial lawyer didn't have number one.
Counsel, you know, the problem with that, and I think the record sort of bears this out to some degree, is that people can have more than one phone, right, counsel?
No, Judge. Well,
No?
yes, certainly other people
Sure.
can have more than one phone.
Sure.
Yes, Judge.
And they can have a burner phone, right?
Your Honor, that's a red herring. Why? Because the testimony of Detective Dillon on R2334 is there is absolutely no proof of a burner phone. It's a complete red herring. And by the way, the evidence is replete.
Did Kramer call your client? Did Kramer call your client on the day of the murder?
He did not. And the evidence shows he did not.
Did your client admit that Kramer called him on the day of the murder?
He did not. My client made he did not, Judge. The phone call happened a week or so later, I believe. There is no admission of guilt in this case by my client.
No. I didn't ask you about admission of guilt. I asked if your client said in his interview with investigators that Kramer Kramer tried to call him on the day of the murder. Yes or no?
Tried to call him is different from calling
And
him.
hold on, and he missed the call, right?
Trying to call somebody is different from calling.
Counsel, Kramer called him and your client missed the call, yes or no?
If that's what his statement is, Judge, that does not bear on the corroboration issue. That's at
Wouldn't that,
issue.
I mean, why wouldn't that show up in the phone records? The missed call.
I don't know why it didn't come up in the phone records, Judge, but the fact of the matter
Could it be
is,
because there was another phone?
Judge, with all due respect, both Mr. Kramer and Mr. Harrington both told the police they had one phone number for my client.
I have the
Not
same
a-
question though. I have the same
Not a
question
third
though.
one.
Wouldn't that come up in the phone records?
It did not come up in the phone records, Your Honor.
So
But the fact of the
couldn't that
matter
inference
is,
be from that that there were multiple phones, or that your client was not being truthful?
the fact of the matter is neither
Yes or no?
Mr. Harrington,
Well, I think we
Your
both
Honor.
have the same question. Okay, go ahead.
Your Honor, there is no evidence that either Harrington or Kramer had any other phone number from my client.
Counsel, that's just not borne out in the evidence. I mean, how do you explain your client admitting that he received a call that he missed on the day of the murder from Kramer, but that phone call doesn't show up in any phone records other than your client had another phone?
Your Honor.
What other explanation is there?
Your Honor, I don't have another explanation for that. I do have an explanation, though, for why the police did not subpoena my client's phone record. They subpoenaed everybody else's phone record, not mine. Why the lawyer did not argue that to the jury that that's reasonable doubt. They subpoenaed cell site tower records, which they admit are critical pieces of evidence. Why didn't they subpoena cell site tower records for my client? And why didn't the trial lawyer argue that as reasonable doubt? And why didn't the judge even reference that in his order? He didn't. Those are all questions. Your Honors, you make good points.
If
I
we could
can't
zoom out for a
prove
little
a
bit.
negative.
If we could
sorry.
zoom out, what is your response to the trial court, the post-conviction court's determination that regardless, your client could have been found guilty under the principal theory? And so, the particularities of whether or not he was the one who actually pulled the trigger and fired the shot that killed the victim is relevant.
Judge Sasso, that's an excellent question. The judge is completely wrong. Why? Because the defense was not that he was there but didn't pull the trigger. The defense was he wasn't there, and these people are lying, and there's no other evidence putting him there. The state never sought him as a principal. The state never argued he was not the person who pulled the trigger. So if the evidence was proved that the witnesses were lying and not credible and impeached their testimony, it was as to the issue of whether he was there or not whether he was or wasn't the shooter. If Kramer admitted to Danae Craig, and by the way, why, Your Honor's query, why is everything else that Danae Craig said verified? She was the lead witness for the police. Everything in this case led from her. Why would she lie about that piece of evidence? Why is that piece of evidence, which is borne out in the sworn statement she gave to the police, the one piece of evidence that was untrustworthy in this case? It's not. Everything else flows from it.
So
The fact of the matter is,
Counsel, you're at 6 minutes, 30 seconds. You can keep going. It's up to you.
Judge, I'll hold for my rebuttal.
All right. And counsel for the state, whenever you're ready.
Thank you, Your Honor. May it please the court, Mr. Wandner. The state agrees with the questioning that the court has made here with the cell records. The cell records don't prove anything other than where a phone might have been, not where a person might be. We know that. We know that the cell records don't definitively show whether or not, Mr. Harrington at the evidentiary hearing testified at the very end saying that he didn't remember whether he really did call Kramer on the day he picked him up or whether he had instructions from called Peters, excuse me, or whether he had instructions from Kramer to go pick him up and where to do that. The evidence vacillates and goes back and forth about who called whom when. And as the court has pointed out, it also misses calls that Mr. Peters apparently acknowledged receiving. So the cell records are not,
Counsel, do you concede that counsel, at least in some respects, was ineffective, and that the only issue is whether there's prejudice?
I do agree with that. I think that he probably should have cross-examined Danae Craig a little bit more forcefully, but Danae Craig never placed Peters at the scene, never named Peter, didn't know Peters. And so she's not the one who implicated Peters. She implicated Kramer to the police when she was in handcuffs and said, oh, he's the guy. But she's the one who robbed this victim the first time and who gave up all this information to Kramer the second time. She gave this stuff to Kramer. So
what's your response to the argument that if this all turned on her testimony, that it's impossible to demonstrate a lack of prejudice, where every aspect that could undermine her should have been introduced?
Well, and that's why I say that it should have been, but I'm also arguing that the trial court was absolutely correct because she didn't implicate Peters. It's Kramer and Kramer's problems and what he said. I mean, Danae Craig, after she spoke with police and gave up Kramer's name, is when she called Crime Line. She called Crime Line 3 days later, after speaking with the police, after giving up Mr. Kramer, in order to make a record of some kind or maybe collect a reward, that she had to call in a Crime Line and say Kramer did it. She'd already told the police that. If you look at the dates, they're in the record, but the date of the Crime Line is after Detective Dillon spoke with her the first time. She's not credible. Even so, all she did was pick Kramer, and Kramer is the one who tried not to name any names, who mentioned his sister as his alibi, and said that he didn't name anyone else who was involved. And when the sister was contacted by the police, she immediately gave that up. No alibi. He told me he did it, and these are the people he told me he did it with. This wasn't a setup by Kramer. It couldn't have been. If it was a setup, it was a setup for him to have an alibi and that he was never there. Instead, she ratted him out as to he admitted doing it and the name. Then the police go to Harrington. Harrington does the very same thing. For right off the bat, being approached and says, here are the people. The difference in the second trial as opposed to the first trial was simply the man who placed Peters with all three of them, with the safe, with the clothing, the hoodies that was likely used. That was the difference. It wasn't whether or not Danae Craig's credibility was damaged. She wasn't a credible witness for either way that her testimony came down. The judge could see that just from the 4 interviews and the way she conducted herself during those interviews. There's nothing.
Her testimony was proffered at trial, right?
It was. Counsel did everything he needed to do to make sure it was a record.
And she explained during the proffer that she was assuming that Kramer killed the victim. That he didn't actually say that. Is that correct?
That is correct. She testified to that in both trials. She was pressed on it in the first trial, and she says, no, I assumed that that's who did it, because it was the only name she knew. Other than maybe this possible cousin, Andrew Kramer doesn't have a cousin named Mike, he says. So we're going to take Danae Craig's word for who the cousin is, or are we going to take Kramer, who's been straightforward all the way through, as the court has noticed? So
it seems like there's a lot of, there is a lot of testimony implicating Peters, but it does. I mean, counsel would say, look, all of the all of the folks who testified had credibility problems. I mean, even Taylor, would you agree with that?
Oh, yeah, without question. They all had credibility problems, but you have to look at the evidence and the reliability of the evidence. Kramer's sister had no reason to just dispense with the alibi and say, hey, this is what my brother told me did it. The Harrington, the guy from the Chicago that they nicknamed Chicago, who said he left town because of the death in the family, he moved back to Chicago. They didn't get him for the first trial. This is why trial counsel wanted to push through the second trial as fast as he could. They did the first trial that way as well. If they couldn't get him, it would have made a major difference. Once they got him for the second trial, he didn't have any reason to come in there. We've got another conspiracy theory. Counsel then suggests, oh no, he had a reason. He could have been in charge as an accomplice. He could have been trying to help out his buddy, his roommate. But there's no evidence of that. They may have been interested in him as an accomplice because he was the one who got the crowbar. But when he was able to tell them he did business, $3,000 a week worth of drug business with the victim, he wasn't involved with that. All he did was say, when I came into the house, I had to go get that crowbar because they had the safe. Peters was there, and they had just done a lick. That's the evidence that sealed this case. And the judge could see that here. It wasn't Danae Craig, the person who already robbed that victim once and tried to set up a second robbery, who would have been the difference in the case. You have to balance all of the evidence. And I think, in my brief, I do a pretty good outline of exactly how this came out to be a conviction. It wasn't because of prejudice due to Danae Craig. If the court has no further questions, I rely on my brief, but I urge the court to realize that Danae Craig and the cell phone records weren't enough to switch this around. They argued principle. There was a jury question in principle, I think even in the first or second trial. And none of that evidence that they're seeking removes Peters from the scene. Thank you.
All right. Thank you, counsel. Counsel for appellant, looks like you have 6 minutes, 26 seconds, whenever you're ready.
Thank you, Your Honors. May it please the court.
Counsel, before you get into any other issues, do you want to say anything about Ryan Douglas? I mean, I think the problem you have there is the trial court's credibility determination. Do you want to address that, or would you rather focus on other issues?
Briefly, I will. Yes, Ryan Douglas was a convicted felon, but so were the other witnesses. The judge made a determination that he may have read a court file when there was no evidence to that effect. And the judge was substituting his beliefs rather than the potential jury belief as to whether Ryan Douglas was more credible. Ryan Douglas had no beef in this fight. He had no motive to lie. Whereas Harrington and Kramer.
Isn't that the trial judge's job at this evidentiary hearing to determine credibility? And didn't the trial court specifically reference Douglas's demeanor?
Judge, he has to base it on reliable proof. He made a conclusion that he may, without any evidence to that effect, may have seen the court file. Harrington testified he didn't have his court files with him in the jail. So there's no evidence that Mr. Douglas ever saw any records. The bottom line is, though, that's exculpatory testimony. The jury should have seen it. And counsel's statement a few minutes ago, balance all the evidence. Well, how could we balance all the evidence when the jury didn't hear the two most important pieces of evidence for the defendant? They've heard it in the first trial, although it was sloppily admitted in the first trial. It was still admitted, and of course, a hung jury. And by the way, when you talk about jury questions and phone records, the first trial had a jury question specifically about the phone records. The second trial, conveniently where he's convicted, the phone records didn't come in, and Danae Craig's testimony didn't come in. And judges, Your Honors, it's not about the credibility of Danae Craig. It's about the credibility of Andrew Kramer. Counsel stated a moment ago that Kramer was consistent all along. Well, that's not true. Let's start with clearly made statements, according to Danae Craig, to Danae Craig where he admitted the crime. Then he apparently made statements to his own sister that Ishmael Peters was involved. His sister, by the way, the phone records where Ishmael Peters is telling somebody over a recorded line that he's being told what to say. Why is the jury, why would it not be powerful defense exculpatory evidence that Andrew Kramer is making different statements? Andrew Kramer's memory was at fault, was at play. His credibility was at play, yet the trial lawyer didn't include any of the issues that we had found in the phone records, didn't even seek them, even though phone records were clearly something that he should have and knew were being used by the state. The fact of the matter is, at the hearing on the post-conviction relief, the judge himself said, I am feeling funny about this evidence. That is an incredibly powerful statement by the judge, R2370. I have a funny feeling about this evidence. Andrew Kramer made a third statement at the motion for post-conviction relief hearing. He says, I don't know if my testimony would be the same if there was a third trial. How could that not be compelling evidence that could lead a jury to believe or disbelieve him? And if you disbelieve Andrew Kramer, that he's the one who shot the victim, how can you believe any of his testimony? And if
it was clear that Kramer didn't want to be there, right? I mean, you would agree with
Kramer
that?
didn't want to be there. That's true. But his statements, Judge, are at issue. His credibility was at issue. Harrington's credibility was at issue. Taylor's credibility was at issue. And it were not for them, there's no other evidence placing my client at the scene at all.
Can we talk very briefly about evidence placing him at the scene? You
Sure.
made an argument below about cell phone records, not just the records, but the site towers should have been.
Yes.
subpoenaed. The trial court found that was speculative on the prejudice analysis. Can you address that very quickly?
Sure. Unfortunately, Judge, the trial lawyer never sought those records, even though he was aware that the state had sought them for the other defendants. Again, the police, I don't understand why, but they never sought them. When I got involved in the case, I subpoenaed the phone company. Unfortunately, they were no longer available by the time I got involved. So while we were able to make the argument to the court that he should have gotten those records, the court's ruling is, well, you don't know what those records are going to show, so it's prejudicial. It's not prejudicial. The point I was trying to make, however, which I'm still making, and the judge never responded in his order, is why didn't the trial lawyer get up and argue that the police failed to subpoena Ishmael Peters, the one guy on trial? They failed to, they subpoenaed site towers for everybody else. They subpoenaed phone records for everybody else, but they didn't subpoena Ishmael Peters' records at all. Why not? And why is that in and of itself not reasonable doubt? And why didn't that lawyer make that argument? He didn't. In and of itself, that's reasonable doubt. In addition, Your Honors, at the end of the day, if the court on a cold record compares the 3 post-conviction hearings and the evidence flow that came from it, what evidence came out as opposed to the second trial, it is night and it is day. The jury should have been given the ability to hear the introduction of evidence that came out at that post-conviction hearing. That would have made a fair trial. My client did not get a fair trial, did not get a fair shake. He struck out because his lawyer struck out. When there's no forensic evidence or corroboration, impeachment is everything. This lawyer failed to impeach these witnesses in any meaningful way. This court must reverse this conviction.
Thank you,
Grant him
counsel.
trial.
And with that, we are in recess.
Thank you, Your Honors.
Thank you, Your Honor.